This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And as promised, we're now joined by the one and only Todd Lutsky from the law firm of Cushing & Dolan. We got the phone lines wide open for your phone calls. So make sure you get calling. 888-205-2263 is the number to ask Todd your estate planning questions live on air right now. Again, 888-205-2263 is the number. We can usually get through 2 or 3 of your calls. So make sure you get dialing in to get your spot in line because Todd tends to be in high demand. Again, 888-205-2263 is the number. Mr. Lutsky, how are you doing today?
I am never better, and you?
I'm good. Did you hear that the duck finally quacked?
No, I didn't hear that.
Confessed to all its crimes.
Oh, that's funny.
No, it was actually foul play. Yeah, it's not good. Todd, I want to talk a little bit about someone who might not have put together an estate plan.
Yeah.
Does the type of assets or accounts that someone owns impact or influence the type of planning that they do?
It can, yeah. The type of assets make a big difference.
How so?
So let's pick some assets to sort of pick on. First, I would say when you're listing assets, and by the way, that's the first thing you should do when you're thinking about your estate plan. List all your assets so you know what you're dealing with. But let's say someone comes in and they've got 5 rental properties, 4 rental, 3. A rental property doesn't have to be multiple.
Sure.
So they might have a home and a vacation home and this and that. But let's just stick on the real estate side. Once they throw in rental properties in the mix of their planning, not only are you going to then say, okay, well, you still need to do your basic estate plan, your will, your trust, your healthcare proxy, your power of attorney. All the basic documents are still going to apply to an individual like that. But in addition to that, I'm going to say, okay, so the objectives are avoid probate, reduce or eliminate your estate taxes, provide a bloodline plan to your family, however you want to leave that, and then decide how much control you want to keep. Okay, so those are your basic ideas. Then I'm going to add, well, since you happen to have a rental property or rental properties, are you at all concerned about protecting those assets or protecting yourself from potential creditors associated with those properties? For instance, the slip and fall, the party where someone falls off the balcony, you name it, and someone gets hurt on the property. If you continue to own that property the way you own it, generally speaking, your own name, or even if you just say, I want to do the basic estate planning and then put that rental property into the trust that you're doing, you have not changed your creditor exposure. Example, if someone gets hurt under those circumstances on the property, they are going to sue the property owner, which is you, and they are going to go after all of your assets, not just that building. Whereas if instead you put that building into a limited liability company, and then you take the shares of that limited liability company and place them into the revocable trust, now when somebody gets hurt on that property and sues, they will not sue the shareholder, which is you. They will sue the entity. And the entity has a building in it. And guess what? Most of the time, the individual creditor doesn't want the building. They want the money.
Sure.
And so now they're going to settle with your homeowner's insurance or umbrella carrier and figure out how to resolve this. And you don't care. You're happy. You got to keep the building. And the lawsuit was handled by your insurance company.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. Still room at the phone on the phone lines for your estate planning questions. Phone number is 888-205-2263, and you get to ask Todd your questions live on air right now. That number is 888-205-2263. We're going to take a quick break here, but when we come back, we'll get to some of your questions with Todd. That phone number again is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. Todd Lutsky answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
Talking with Todd Lutsky. We still have room on the phone lines for your estate planning questions at 888-205-2263. Again, that number is 888-205-2263. Let's go to Norman in Portland. Norman, what's your question for Todd Lutsky?
Hi. Well, I think he was just describing me. I got a house that I'm renting in Massachusetts, but I live in Maine. I was wondering, is that a special difficulty being out of state?
No, it's not. It's not any more difficult at all. What I can tell you though is, and since you do live out of state, and I think this is a great question for everybody else who's listening right now. Understand, living out of state, there's one other issue you might not have been thinking about, and that is, I'll describe it this way. I did a seminar once for somebody called "So You Think You've Changed Your Residency." It's not always so easy. And so when you are a non-resident in Massachusetts and you own real estate in Massachusetts in your own name, Massachusetts will tax you when you die as a non-resident on the value of the property you own in Mass. So, for example, if you had $2 million property in Mass and your entire estate, all the stuff you own on your own in Maine, wherever else, let's say adds up to $4 million. So your entire estate is $4 million, but $2 million of it is Massachusetts property. They will divide that out, so that's 50%, right? And then they will calculate the tax in Mass on $4 million, your entire estate, and then hit that number with 50%. So they'll take 50% of the tax on $4 million. So you need to be mindful that you don't want to be paying Massachusetts estate tax even though you're a non-resident. So, one, we got to do an LLC. How do we prevent this taxation by Massachusetts on non-residents that own property in Mass? You take the property and you put it into an LLC. Once it's in an LLC, you've effectively converted the Massachusetts real estate to what they call an intangible. What do I mean intangible? It's a stock certificate. It's an intangible. You don't own real estate in Mass anymore. And so then Mass cannot tax non-residents on intangibles. And so now you avoid the Massachusetts estate tax. So that's not why you called, but that's another reason you should be doing this. Now, the creditor reason you should be doing this is if somebody gets hurt, right? So we simply put this into an LLC for you here in Mass, and the operating agreement will be here in Mass. You shouldn't have to file in Maine because you don't own the property in Maine. You just have to file in Mass. And now, if somebody gets hurt on the property, they will sue the entity here in Mass. They will not sue you as the shareholder, or hopefully your trust as the shareholder. And again, the reason you want to put the shares of the LLC into the trust is because you want to make sure you avoid probate when you pass on all assets, right? And in all states. So you certainly don't want to have to go to probate in Mass and basically file in Maine and do an ancillary probate in Mass. So seemingly simple question, but hopefully I gave you a lot of information. And folks, I hope I helped a lot of you out if you're someone listening who has property out of state or has property in state, but you've moved out of state to avoid Massachusetts estate tax. Folks, that said, a lot of people haven't even done their estate planning. So how do we kick off your estate plan this year? How do we get your estate planning going? The guide called Back to the Basics will really help you. That's what we're giving away this month. It basically lays out things to think about before you go to the lawyer. You know, how old am I? What's the family dynamics? As Chuck asked me earlier, what's the value of the assets that I have? You know, and then the guide continues to basically give an estate plan. It's an engagement letter basically that I put together for a $4 million client, advising them how the will works, how the trust works, how the living will, the healthcare proxy work. In this case, we've recommended an irrevocable trust, so you'll learn all about how that irrevocable trust works along with the basic documents as well. Folks, get your estate plan in order today. Get the guide Back to the Basics, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com. And you could go to our Instagram page, Cushing Dolan PC, for more information.
Todd, when we talk about family dynamics influencing an estate plan, can you give a little bit more color as to exactly what may come into play on that front?
Yeah, I think when we start asking clients about family dynamics, we're meaning, do we have, somebody who might be, drug addicted or alcohol addicted? Somehow that's a lifelong thing you have to deal with. What if you have children who are, they're level-headed, but they're horrible with money, or they just spend money like there's no tomorrow. They don't know how to deal with finances. Well, that's important. What if you have somebody who is a disability, has a disability, is a special needs child, or became disabled later in life and is getting some kind of governmental benefits? Well, we want to make sure that we don't, lose those governmental benefits. So when you're setting up the trust, and another thing to think about is just in general, if you don't have any of those things, what about, someone who's got married, has kids, and you're just worried about that relationship. You're worried about a future divorce from your children after you die. I mean, folks, family dynamics come in all kinds of flavors. And with these trusts, we talk a lot about state taxes and probate, and I get all that. But remember, the family behind the estate plan is critical. And so these trusts can live on after you die, long after you die, and provide for your children, your grandchildren, and even your great-grandchildren sometimes. And so you can really control things from the grave. So, the way you set up the trust might be with that disabled child. I don't want to leave it outright. I want to leave it in trust. I want to have it so that the child can continue to get the governmental benefits, but at the same time be able to enjoy what we're leaving them. In other words, you don't have to disinherit that particular child in order to provide for them. In addition, what if I've got that special needs, not that I've got a drug-related child? Well, again, this person or a spendthrift. I don't want to leave this money outright to the child because they'll just blow it, but I want to have it in trust so that it comes out over time, and it provides for them for not only during their life, but maybe even into retirement.
Is it generally accurate to say then that regardless of the specific concern that you may have about a family member or family members and how they may inherit certain assets, there's typically a legal tool available to help alleviate that concern to a certain extent? You just might not know what it is.
Yeah, I think, and to be safe, you can use general language that we do, or I think generally speaking, there's never any harm done if you draft something with a lot of flexibility that actually holds the assets in trust rather than gives it outright. As a general rule, even if the kids are, great, level-headed, you still worry about future creditors, and a future creditor could be any creditor. It doesn't have to be a divorce, but certainly divorce resonates with people. So to me, even if you don't think that there's a lot of other, standout reasons to provide the trust to live on,
sure,
why not just put it in a sole discretionary payout trust so that the kids don't own it right away? Therefore, if something comes up later, after you're dead, it's protected. Yet it's drafted in a way where, they're the trustees. they're managing it, they're investing it, they're buying and selling property, and but just not owning it, so that if something comes up later on, then the asset is protected from that particular creditor, or more likely than not, a divorce. So I think just giving it outright is never a great idea.
Mr. Lutsky, thank you so much for joining us today. We really appreciate it.
Always a pleasure. Thanks for having me.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.